I hope we can resume our workings. Welcome back. My name is Tudor Chiuariu. I'm an associate professor within the Faculty of Law of the University of Ionescu, and I have the honor and the pleasure to chair this second panel of our conference. Like this. Thank you. So, Professor Flogaidis introduced a bit his topic from today, which is an important initiative linked directly to our theme of the conference, the Rule of Law Initiative of the European Public Law Organization. So Professor Flogaidis will be the guest lecturer of our panel. And we'll continue with three different perspectives, I could say case studies from different countries regarding the developments in constitutional law related to rule of law. Dr. Konstantinos Margaritis will present aspects, developments from Greece. Our colleague, Professor Marieta Safta, will outline the main developments in the jurisprudence of the Constitutional Court of Romania regarding maintaining social peace. Mrs. Eliza de la Nuez Sanchez Cascado, Secretary General of Hayderejo Foundation from Madrid, Spain, will outline the developments in Spain regarding the rule of law, and especially the very heated debate on the appointment of High Court judges, Supreme Court judges, and constitutional judges. And last but not least, these are the country reports in a way. We have the honor to have as a guest Mr. Mario Marazziti, which took the opposite way from our previous guest, Renate Weber. Renate was a long time NGO activist, and now she is in a governmental position, and you took the other way around. So you were in the legislative, you are a member of the parliament, you are in the public sphere, and then now you are part of NGO movement, which you are very keen to find out more with the occasion of your presentation. So, Professor Flogaidis, please, the floor is yours for your intervention.
Thank you very much, dear President and friend Tudor. Ladies and gentlemen, I will express first of all my deepest thanks to the university, to the Faculty of Law, and to Tudor Chiuariu for having entrusted me the role of keynote speaker in this panel. At the end, towards the end of the 19th century and the turn to 20th century, a scholar who was a professor in the University of Oxford and winged by conviction, he was also in politics. He wrote a book, an introduction to the law of the Constitution, and he taught a lot on it. And one of the main themes of the book was the introduction to the concept of the rule of law. The rule of law being, according to him, one of the fundamental characteristics of the British Constitution. So the rule of law, which of course is an expression which he did not invent, but the rule of law through him became a point of reference. A point of reference, however, for a strange reason. Not because of what he thought the content of the concept of the rule of law is, but because he advocated in that book that there is another country which does not have the rule of law and which has a strange system called droit administratif. He did not even want to translate it in English because he said it is not translatable. It would contaminate the orthodoxy of the British Constitution. Another country has not the rule of law, has droit administratif, and this cursed country was France. So the biggest part of the discussion about the rule of law was not about what the rule of law is, but about France having a strange system. And because of this antinomy that he found in the two systems, the rule of law was attracted the interest of scholars in the 20th century up to today. And it is interesting to say that, first of all, if you read carefully the rule of law and what Dicey, was his name, A.B. Dicey, thought the content of the rule of law is, that perhaps there are other contents of the concept of the rule of law. And second, one understands that he misunderstood the French administrative law. And actually, later, when Gaston Gèze, a big figure of the same times in France, translated the book of Dicey in French, then Dicey wrote an introduction. And in that introduction, it is so grateful that he accepts that he maltreated the droit administratif, and he was wrong. Of course, in the new edition of his book in England, he did not change the pages of his mistakes. But so are professors. And we know what professors are because we all share the same quality around those themes today. The rule of law, ever since, became famous, used by politicians, by lawyers. The content was shaped and reshaped. At the end of the day, I'm not sure if we can all agree what the rule of law is. The French Revolution took over the idea of the rule of law, despite what Dicey said later. And they produced le principe de l'égalité, ou de la juridicité, ou l'état de droit, and the Germans Rechtsstaat. So one can also start thinking what the exact boundaries between those concepts are, and if they always mean the same. According to Dicey, the rule of law means that nobody is exempted from the force of the law. Second, that there should be only one jurisdiction, the ordinary courts to enforce the law, and everybody should be subjected to the ordinary courts. And number three, that the law is developed not only by the parliament, but through the case law of the ordinary courts. As you see, the context which he adopts is the one which describes the situation, the legal situation in England in the turn from the 19th to 20th century. This is the reason why the content to the rule of law which gave A.V. Dicey is not to be more, but just a point of inspiration in modern times. On the other hand, in modern times, as I said, the expression of rule of law, we must be under the rule of law, we must all respect the rule of law, has become something too easily referred to, too easily used, and especially by political scientists, administrative scientists. Everything is rule of law. Transparency, anti-corruption, all sorts of those, accountability. Everything is deriving from the rule of law, and perhaps it does. But at the end of the day, we cannot catch anymore the true essence of the rule of law in legal terms. The European Public Law Organization that I have the honor to direct has decided before the pandemic to address the rule of law globally. It means at the worldwide level, because it is needed for civilized human communities to have a respect to the rule of law, or at least that's what the few of us who are in this organization, that's what we believe. It doesn't mean that everybody must believe the same thing. And we thought that it is needed to take an initiative to work on the concept of the rule of law in a dialogue of civilizations, in a procedure of fusion of cultures, in a discussion of respect to each other, not only in our small world, Europe, but globally, at the international level. The European Public Law Organization has the status of permanent observer to the General Assembly of the United Nations, and it has this status because we, of course, asked for that and we were granted that, but we did that because it is in the treaty governing the EPLO that we should work closely with the United Nations system. So, thinking globally, despite the fact that we were born by a region in the world, Europe, is not foreign to the constitutive elements and treaties of the EPLO. So in November 2019, Professor Giuliano Amato, President of the Constitutional Court of Italy up to a few weeks ago, took the initiative to introduce in a special event that we organized in the United Nations in November 2019, the initiative to propose, to announce, to launch the idea of the EPLO to work in the area of the rule of law through a global rule of law commission. Because everybody works in the area of the rule of law. But we thought that what is needed, for what concerns us anyway, was to create a European, a global rule of law commission. Global meaning covering the globe, a rule of law. I just mentioned where it came from, and commission. You know that all the commissions, the committees of the United Nations are organized according to a geographical repartition of the work in groups. And so we followed the example. We would follow the example, and we would offer the work of this commission to the United Nations. Because the United Nations realistically cannot produce a global rule of law commission. Why? Because they work through consensus, they decide through consensus, and there are states around the globe which are very suspicious to initiatives about democracy or human rights or rule of law, whatever you name it. But we are not United Nations. We can do whatever we believe it is good for the contribution of the EPLO to the advancing of civilization worldwide. So we made that announcement, and that announcement became moot for 3 years because COVID did not allow us to have the results which we thought. However, I don't know if COVID is over, but I know that we are here today, COVID or no COVID, and things now move differently. And yesterday, our representative to the General Assembly of the United Nations took the floor in the 6th Committee of the United Nations to announce the Global Rule of Law Commission, and with the following characteristics. This Rule of Law Commission is composed of 17 members, 6 from the Western European and others group, 2 from Eastern European countries, 3 from Asian countries, 3 from African countries, 3 from Latin American and Pacific Islands countries. And it will work under the presidency of Giuliano Amato, and it will be headquartered in Cascais, Lisbon, Portugal, where it will develop under the aegis of the President of the Republic of Portugal, Marcelo Rebelo de Sousa. This commission will have as a mission to advance the concept and a comprehensive concept of the rule of law valid globally. And also it will advise governments and institutions on issues of the rule of law if asked. It will never try to develop police powers of any kind, and or to criticize or to intervene in internal affairs of any country in the world. We asked the states to propose to us focal points, so that with the time we may have focal points in every country of the world. Every year, this commission will produce a report which will be presented to the General Assembly of the United Nations. So we are making one step ahead. We have recruited the members of this committee, high-level lawyers from all over the world, and we will do our best to give substance to what I am describing to you today. It is difficult to describe something which has not yet given results. It may give results, it may not give results. One must be realistic. But we're trying, and we're trying hard and seriously. And we're very proud that yesterday the international community presented into the 6th Committee of the General Assembly of the United Nations, followed our presentation, and now they know that we're trying to contribute to the development of the legal principles and legal civilization around the world. I will close my intervention by saying that this commission will be supported by an institute which has already a director and is headquartered in Cascais, Portugal. And this institute, along with the whole operation, will be very happy to liaise with your initiatives here, because the success of this new institution will depend on interactions and on respecting cultures, legal cultures, and the cultures in general from all over the world. It is not an easy experience. You know, when we talk among ourselves in Europe, we understand each other because we have the same common past, more or less. We have the same common past, especially in the area of law, the common understandings, the common references. But the world is much, much bigger. We are a small village in the world, and everybody needs to be respected. Nobody is expecting us to give them lessons about how to organize their society. No one. And this is the strategy on which this Global Rule of Law Commission will try to work. We're going to have another event on 15 November in the United Nations to tell them that we did not forget what we promised 3 years ago, and we have done our job in those 3 years. Not as quickly as we had dreamt when, foolishly enough, we said that we're going to do that, although we knew that COVID was already around, knocking on our doors. But anyway, we are going to I hope that in your next dear Tudor conference, because now we're going to expect the third conference, I will have something more tangible to present to you. Thank you very much for your attention.
So we will continue with the challenges posed by the COVID pandemic, and we will pass to the presentation of Dr. Konstantinos Margaritis, which is an adjunct deputy academic at the Hellenic Open University in Patras, Greece, who will update us on the rule of law and law of emergency. Dr. Margaritis cannot be, unfortunately, today here with us, but he is with us online. So if he hears us and can take the floor, Doctor, the floor is yours.
Thank you very much, Professor. Can you hear me?
Yes.
Okay, that's great. Thank you
Yes,
very much.
please.
And
Proceed.
I would also like to thank the Scientific and Organizing Committee for accepting my paper for this second edition of the International Rule of Law Conference, and provided me with the opportunity to participate in such an exciting academic event. And also I would like to express my apologies for not being able to attend in person, but certain professional commitments here in Greece did not allow my trip to the beautiful city of Bucharest. And I would also like to thank Professor Flogaitis for his very insightful presentation. So the aim of my presentation is to discuss the application of emergency law in Greece during the period of the first economic crisis and the pandemic crisis from the rule of law perspective. And since we cannot have a complete worldwide opinion on what the rule of law is, I will focus on Lord Bingham's principles on the rule of law. First of all, during the last decade, Greece has been in the middle of several crises. First, the severe economic crisis with tremendous effects in all aspects of economic and social life, and right afterwards, the COVID-19 pandemic that seriously disrupted the normal course of life, as pretty much everywhere in the world. During both crises, several measures were introduced through the emergency law process. But before we see the constitutional tools that Greece used to confront both crises, let's briefly remember Lord Bingham's 8 principles on the rule of law, published in his book under the same title. Contrary to theories that understand the rule of law as a formality in the government functioning, Lord Bingham embraced a substantive scope to the rule of law by pointing out its aspect regarding the level of human rights protection. For the purpose of this presentation, I will focus on the principle at the 4th bullet in bold, which states that ministers and public officers at all levels must exercise the powers conferred on them in good faith, fairly, for the purpose for which the powers were conferred, without exceeding the limits of such powers and not unreasonably. Here one may distinguish 5 elements within that principle: good faith, fairness, purpose for which the powers were conferred, the limits of the powers granted, and reasonableness. This particular principle, first and foremost, reflects the very essence of the Constitution. The Constitution grants power to a particular formal institution and at the same time sets the limits of its exercise, limits that the institution shall respect. On the other hand, the need to preserve that principle led to the system of checks and balances in order to ensure that a particular institution does not become too powerful. Now, moving back to the Constitution of Greece, Article 44, paragraph 1 provided the basis for emergency measures taken in both the economic and the pandemic crisis. As we can see, the provision allows the President of the Republic, upon the proposal of the Cabinet, to issue acts of legislative content under extraordinary circumstances of an urgent and unforeseeable need. So here the constitutional provision sets three prerequisites for the adoption of acts of legislative content. First, the circumstances must be extraordinary in the sense of severe deviation from the regular course of life, a natural disaster, for example. Secondly, those extraordinary circumstances raise the need for urgent lawmaking, which the sometimes time-consuming legislative procedure cannot satisfy. And finally, that urgent need must also be unforeseeable, not possible to be predicted according to the normal standards. Regarding the legal status of the acts of legislative content, they are considered legal norms essentially equal to ordinary laws, where the President of the Republic has no discretionary power to act. As we know in practice, whenever the Cabinet has proposed an act of legislative content, the President has never denied to issue them. Although the Constitution practically remains silent on the matter of the President's powers in that regard, the approach that is followed is in line with the nature of the Greek parliamentary republic in order not to create political tensions between the President and the government. Of course, what is quite obvious is that the Cabinet essentially replaces the Parliament in the lawmaking process. The necessary constitutional balance to the extensive power vested to the Cabinet under this process is provided at the same provision. Thus, the acts of legislative content shall be submitted to the Parliament for ratification within 40 days either of their issuance or from the convocation of a parliamentary session. They should be ratified by the Parliament within 3 months of their submission, otherwise they cease to exist, but only henceforth. Let's see now the application of this constitutional framework in practice by using some statistical facts. A small disclaimer here, the term economic crisis encloses the period between the first austerity package in 2010 and the exiting of the bailouts as declared in 2018. So from the establishment of the Third Hellenic Republic until just before the beginning of the economic crisis, more or less 90 acts of legislative content had been issued, and the number of those acts during the time of the crisis exceeded 70. Therefore, in a period of 8 years, we had almost the same number of acts of legislative content compared to a 35-year time span. The measures to prevent the spreading of COVID-19 fell under the scope of Article 44 of the Constitution as well. Since February 2020, 13 acts of legislative content have been issued for taking measures to tackle the spreading of COVID-19, covering all aspects of public life, for example, the lockdown, the closing of educational institutions and distance learning education, the operation of public services, etc. So it wouldn't be exaggerative to argue that throughout the year 2020, the application of emergency law had gradually become the normality. And even if the application of the emergency law framework is understandable in the case of COVID-19, since the country had to deal with an unprecedented situation of a highly infectious virus, which could cost thousands of lives, the same argument cannot be used for the period of the economic crisis, at least not in its entirety. Several acts of legislative content were issued without fulfilling the prerequisites of Article 44. Those include the recruitment of officers in the security forces, the assumption of the loan obligations of 2 municipalities from the Hellenic Republic, the fund of the employees of the Parliament, the establishment of detention centers, and the transportation of pupils and the proper beginning of the 2015-2016 school year. That included actually 4 acts. And those are just some examples. All those examples could have been regulated under the ordinary legislative procedures, which would in no way affect the effectiveness of the regulation. Therefore, this excessive use of the emergency law framework raises a strong question under the system of checks and balances. Which institution could probably check whether the constitutionally set prerequisites for the adoption of acts of legislative contents have been fulfilled? So here a possible solution could be the President of the Republic when issuing the act. However, as I described before, the President is bound by the decision of the Cabinet. Another option could be the Parliament when ratifying those acts. Nevertheless, that is also problematic for two main reasons. The first is political. In a parliamentary republic system, the governing party enjoys the confidence of the parliament, having the absolute majority of the seats. Therefore, non-ratification is highly impossible. And the second one is constitutional. Even in a non-ratification scenario, the acts will cease to be enforced, but only henceforth and not retrospectively. Therefore, the regulatory consequences have already applied in the real world up to the point of non-ratification. A third option that someone could think could be the courts of justice through the process of judicial review, which is, by the way, decentralized in Greece. However, in its well-established case law, the Council of State has emphatically underlined that the fulfillment of the constitutional prerequisite of Article 44 is not subject to judicial review, since they fall under the sphere of the internal matters of the Parliament, and the Parliament is competent to decide when ratifying the acts. In any event, we end up in a peculiar position where no institution can provide an effective control in the will of the Cabinet to apply Article 44. This being the case, the balance among institutions in the separation of power doctrine is shifted towards the executive. So, the persistent and general use of Article 44 during the economic crisis demonstrate non-compliance with the rule of law principle as developed by Lord Bingham. Article 44 inserts a lawmaking route that establishes an exemption from the regular one. Therefore, the constitutional provision outlines the cases of emergency legislation and provides for the relevant process. In that respect, the decision on the application of this process shall be based on a case-by-case evaluation and be extremely precise on the fulfillment of the prerequisites that the Constitution sets. Even if someone can accept that in cases of crisis, several procedures must be more flexible in order to achieve the best possible result on a pressing matter, the constitutional safeguards need to remain in force, especially in the legal order of Greece, where the emergency process is aptly described in the Constitution. The Constitution itself provides the appropriate level of deviance from the regular legislative procedure in order to achieve this institutional balance. During the period of the economic crisis, we have several cases of manifest abuse of Article 44, both regarding the purpose for which the powers were conferred and the limits of those powers. That implies that in those cases, the government granted itself power in a manner not predicted on the Constitution. And finally, the absence of a system of checks and balances in that regard intensifies non-compliance with the rule of law principle. Thank you very much for your attendance. Thank you very much. I have finished my presentation.
Thank you very much, Dr. Margaritis, for your presentation. And we shall pass then to Mrs. Elisa de la Nuez Sanchez Cascado, who will talk about the situation of the rule of law in Spain, risks and threats. Please, Elisa, the floor is yours.
Thank you very much. Thank you very much for the invitation to this conference. I will present my organization briefly. It's a civil society organization. It's a foundation. It's called Hay Derecho, which means rule of law in Spanish. And our main purpose is promoting the rule of law and fighting against corruption and promoting transparency. We'll be presenting a report on the state of the art of the rule of law in Spain next month. And I want to share some of the key findings with you. Right now we have an important constitutional crisis back in Spain because yesterday the President of the Supreme Court and President of the Council General for the Judiciary resigned. And the cause is that this General Council of the Judiciary has been blocked for 4 years now, almost 4 years. It had to be renewed in 2018, and it hasn't. So his president has resigned as a cry for help. And we had also the Justice Commissioner in Spain like 2 weeks ago. We have a meeting with him. He was very worried about this constitutional crisis, and he came to Spain to try to mediate between the political parties, and well, he has failed, as we have seen. I want to highlight this problem because for us it's like a symptom of the problems that the rule of law had in Spain. And I think, as I listened to the previous lectures, that it has something in common with other problems here in Eastern Europe and especially in Poland. It's about the separation of powers. Our General Council of the Judiciary is elected, 20 members are elected by Parliament, and it has been like that for almost 40 years. It wasn't like that first in the Constitution. The Constitution were more or less open, and it said that 12 of the members of the judiciary could be elected by judges. It was so until 1985. And the law was changed because the government back then thought there were too many judges coming from the Franco era, so conservative judges, and they thought it was better that all the members of the General Council of the Judiciary were appointed by Parliament, and it has been like that for just 37 or 38 years. The problem is that our Constitutional Court said in 1986 that was okay, but it said also that couldn't lead to a system of party quotas. It says it's okay if all the members of the Council of the Judiciary are elected by Parliament, but agreeing about the candidates and not in a system that says you've got so many candidates, another party so many candidates, like that. In order not to do the same thing as the Congress, I mean, not to replicate the majority in the Congress. It's important. But it hasn't been like that. In fact, we got a party system, a party quota system. The problem is that our General Council of the Judiciary appoints the top judges in Spain. So, like that, the politicians have a big influence in the appointments of the judges in the Supreme Court and another important position in the judiciary. Why is that important? It's because there are many important corruption cases that goes to the Supreme Court. Also because our politicians have a special status before the courts. It means that they only can be accused before certain courts, especially the High Court. So, and also because in public law, the most important cases go to the High Court. So they can influence the outset of the very important judicial procedures. I have to say immediately that in Spain there are like 5,000 judges, and most of them, the immense majority of them, are quite independent judges. I am speaking only about 40 or maybe 50 people in the judiciary, which are not many, but they are in important positions, and that is like casting a shadow all over the separation of powers in Spain. That's the problem, and it has been going worse and worse because when there was a change in our government back in 2018, the Council of the Judiciary had to be renewed, but the main opposition party The Conservative Party didn't want to replicate, like has always been the case, the majority in government, because it will change the majority. And the actual government wanted to renew the Council of the Judiciary because it will benefit this party, and they couldn't reach an agreement which is needed to select the members of the Council of the Judiciary, and like that we have been like for 4 years almost now with that Council of the Judiciary without renewal. As I say, the main issue is the appointment of the top judges. So the government decided that an interim Council of the Judiciary couldn't appoint these top positions. So they decided, they passed a law like 1.5 years ago to forbid the Council of the Judiciary to appoint these top judges while it was an interim body. That has caused many problems because there are a lot of vacant top positions now, especially in the High Court, and that's affecting the ordinary procedures there, and is leading to delays and all kind of problems. And but when they passed this law, they forgot that our Council of the Judiciary also appoints 2 members of the Constitutional Court. That means that they couldn't appoint these members of the Constitutional Court, and the government was very worried about that because our Constitutional Court has now also the need to be renewed, and they couldn't do that. So they passed another law, that was 4 or 5 months ago, say, okay, it's an interim body, they couldn't appoint the top judges in the judiciary, but they can appoint the judges in the High Court. And that was very criticized. We criticized that a lot, because if it's an interim body, it's an interim body for every appointment. But right now, there is no agreement on these appointments also for the High Court, for the Constitutional Court. So we got blocked 2 constitutional bodies now, the General Council of the Judiciary and also the High Court. So quite a constitutional problem. And that is putting a lot of stress in our system, our rule of law system. But what we want to point out in our report is that there are structural problems going back to almost the 1980s or 1990s that hasn't been solved. The main problem, as I say, is the separation of powers. Our main political parties don't want to change that system. They also promise to change the system when they are on the opposition. Both of them, when they are in the opposition, they say, okay, let's change the rules. We need a more independent Council of the Judiciary. We need separation of powers. But when they get to the government, they have the power, they don't do that. But the trouble now is that they are defending that the judiciary has to be appointed by the parliament as a way to say that it's more, or they say it's more democratic. And that's also a concern for us in Spain, because that used to be more discreet, so to say. They used to share this system, this party quota system, but they didn't really say that in public. Now it's being said in public, like, okay, let's do that. It's more democratic if we select the members of the judiciary straight from the parliament. So it's like a discourse or debate who is going along these lines. I think they're very worrying, because as I said before, that was the case always, but it wasn't so open. And now it's like that. And also we got some very hard criticism of not only of the rulings of the courts, which are against the government, or in Spain we have a very complicated territorial system. We've got a lot of regional governments, but I say government, it means state government, but also regional governments, which are different from different parties. And each time they got a ruling that is against their interest, of the government interest, we got a very, very hard criticism, not of the rulings, of the sentences, but of the judges that are behind them. So I think it's also a very worrying situation, because they are calling, they are investigating judges, saying if they are conservative or they are progressive, or even their family is not really a very good situation, especially for the judges involved, especially in big corruption cases. We got a big corruption case lately in Andalusia, which is on all our regions, and the former president of the regional government was sentenced to prison, and is from the same political party of the state government, and they are going to ask for pardon for him. So it's like saying politicians are above the law, and even if they got a sentence and they are sent to prison, they can be pardoned, so it isn't really effective. And we got also, as you may know, another big constitutional crisis back in 2017 regarding the referendum of secessionist referendum in Catalonia, that led to a High Court ruling that sentenced to prison the main leaders, but these leaders were after pardoned by the government, because the government is now in coalition with the nationalist parties in Catalonia. So apart from the fact that the ruling was okay or not, it has been they have appealed to the Strasbourg court, but the message they are sending is like politicians are really not accountable about anything, as far as there is a government that can pardon them. And I must say also that our pardon law it dates from 1870, and it hasn't been changed because it's very useful for governments. And I mean all kinds of governments. They usually agree, the main parties agree who has to be pardoned. So they don't make really a fuss. The opposition doesn't make a fuss about that, because they agree on that. Also, I wanted to highlight another problem that is, I think, very important, is the lack of autonomy and independence of the Prosecutor General. We got recently a Prosecutor General, which was the former Ministry of Justice. And she used to say she was there to implement the politics, the criminal politics of the government. And we thought, and we think, that was a very, very bad conception of the Prosecutor General, because we need, well, it's said in the statute of the Prosecutor General, they have to be independent and only submitted to the rule of law. But in fact, the Prosecutor General was saying she was taking, I don't know how to say, orders, but maybe ideas or whatever from directly for the government. And as I said, she was the former Ministry of Justice, so she didn't know what to do in any case. She was involved in quite a series of scandals regarding lack of neutrality and impartiality. So I said it's also a problem. These two problems have been highlighted in the European Rule of Law report this year and the previous year. They also have put on the table some recommendations in order to fix these problems, but I'm not very sure if we will be able, or our parties will be able to solve these problems. I wanted also to mention another thing that is highlighted in our report is about the situation of the checks and balance, what we call these other constitutional bodies that are supposed to be independent and overseeing the government, overseeing the executive branch. And that in Spain are most of them very politicized in terms that the political parties appoint the members of their boards and makes it very difficult for them to be independent and fulfill this mission of overseeing the executive power. For example, I am talking about the Court of Auditors, of the Ombudsperson, the Constitutional Court, that are usually, their members are usually elected by partisan reasons. They are very close to political parties, so we got quite a problem there. One example of that was a very recent appointment to the to the presidency of the Data Protection Agency, which is supposed to be also an independent body, and the main political parties decided to nominate for this position, for the presidency and the deputy, two persons from each one from one political party. They always do the same thing. But they forgot that the law did have a system, an open system, a concurse system, to select these two members. So we go to court. We went to court to denounce that. And our High Court says it was not how the law said the appointment must be made. And I think the interesting thing is that the political parties just forgot about the law. The law said you have to open a concurse, you have to select the candidates that are more suitable for the post, and they just forgot about that when they were exchanging the names. So I think, well, it's not going well. We have covered like 5 years in our report. We've seen that there are many indicators that are going the wrong way. We're seeing a certain decline in this kind of examples I'm giving you, because as I said before, that it was always the case like that, but now it's like more open and even defended in public. Another problem we got, and I think it's a very important problem for a rule of law system, is the problem with the execution of the court rulings of the sentences. When the sentences are against or the interest of the government, there are big delays in their execution, and sometimes they are even not executed at all. So that it's like doesn't serve for any purpose. And that's especially true when there is a pardon, as I told you before, which is the case in many important corruption cases. Another, and I don't want to tell you about all our key findings, because our report is like 80 pages long, so it's too much. But another problem that has been going on for some time is the legislation with executive decrees. What is an executive decree? It's a legislation that is special, is made by the government, not the parliament, and is also allowed in exceptional situation and a situation of urgent and urgent need, extraordinary and urgent need, is what our constitution says, but its frequency has been going up and up. And now it's like the ordinary means of legislation. What is the problem? The problem is the drafting is less technically not so good, because they don't need to ask for many reports that have to be asked in ordinary procedures, and because the Parliament has also a say in saying, okay, it can pass or it can't pass, but there is not amendments, not way to make this legislation better, and also because it cannot cover all the topics that as an ordinary law can. And well, we got some figures that says that now is the norm rather than the exception, and it goes along with a decline in technical quality of the laws. And as I said, the oversight of the Parliament is really not very good at all, and its contents cannot cover a lot of topics, but in fact they do. And the problem is that you can only go to the Constitutional Court to see if these executive decrees are constitutional or not, and it takes a lot of time. And I don't think if I have a little time. No, I will finish it now. No, okay. I will finish it now, and we cover a lot of topics in our report, and I think you can share the report with whoever has an interest, and if you've got some question, I will be delighted to ask them. Thank you.
For this very comprehensive presentation, and I think it would be food for thought for the discussion that will follow our panel. And we'll naturally pass to the last country report done by our dear colleague Marieta Safta, which teaches constitutional law within the Faculty of Law of Titu Maiorescu University. Which Professor Safta will refer to the role of the Constitutional Court in maintaining social peace. Apart from being our colleague, Marieta is also a magistrate assistant to the Constitutional Court of Romania, and contributor to the European Review of Public Law, the publication European Public Law Organization. The presentation from today is co-authored with Professor Tudorel Toader, the rector of Alexandru Ioan Cuza University from Iași, Romania, and also a former constitutional judge and Minister of Justice. So please, Marieta, the floor is yours.
Thank you so much, Tudor, for this introduction, and also thank you very much for the invitation. Esteemed professors, organizers, dear colleagues, it is indeed a pleasure for me to be here today with such distinguished speakers debating one of the crucial topics of the moment, rule of law after the pandemics, in times of war and economic crisis. So together with Professor and Rector Tudorel Toader, former judge at the Constitutional Court of Romania, we proposed a paper entitled The Role of the Constitutional Court in Maintaining Peace. In fact, the topic of this conference gives us the opportunity to approach an issue, the significant impact, recently discussed in the framework of the 5th Congress of the World Conference on Constitutional Justice and Peace, which took place in the first week of October, and reunited more than 90 courts of constitutional justice and equivalent institutions, and almost 600 participants from all over the world. I had the opportunity to participate in this amazing event as a member of the delegation of the Constitutional Court of Romania. During this event, it was emphasized the role of the constitutional justice under challenging periods like war, pandemics, or in the context of situations when hot topics polarize the society and threaten the balance of powers and the democratic values that define the rule of law. Consequently, the concept of peace we are using here is not the concept of public international law that relates to conflict between states. It is used in the sense of peace within the state, as the peaceful settlement of disputes of various natures. In this regard, the constitutional courts play a key role. I have noticed that also Professor Spiridon Logaidis emphasized the role of the courts of law in upholding and developing the concept of rule of law. Coming back to the constitutional courts, I think that all the powers of the constitutional courts compete to achieve the goal of social peace, like, let's say, a main dimension of the rule of law. Thus, the regulation of new powers, more or less different from the traditional role of the constitutional courts as simple negative legislators, appear as justified. In the current era, the constitutional courts belonging to the European model, the main model at least at the level of European Union, are not only judges of legal norms, but also electoral judges, arbitrators in the legal conflicts between public authorities, or guards of the constitutionality of the political parties. In this respect, we consider that the powers of the Constitutional Court of Romania are a result of evolutions in terms of diversifying and strengthening the constitutional review. Through the wide range of powers, both regarding the review of normative acts as well as facts, attitudes, the court substantially contributes to maintaining social peace. Taking account of the amplitude of this topic, in our study we refer only to two coordinates that we particularly consider meaningful from the perspective of the rule of law. The relations between public authorities, in the sense in which we will mainly refer to the resolution of the legal conflicts of constitutional nature, and the protection of fundamental rights, with a special reference to the case law of the Constitutional Court in the context of the pandemic. Based on the research, the study's conclusion sheds light on the need to strengthen constitutional justice as an essential control and balance mechanism in the rule of law. So the first point is the resolution of legal conflicts of constitutional nature. We already had a multi-perspective approach of the conflicts on the rule of law, I think provided by our colleague Martin Wendelski in the first panel. But in my presentation, I will focus on the horizontal conflicts and internal conflicts between public authorities within the state. So perhaps the most obvious in terms of maintaining social peace is the power of the Constitutional Court in this regard on the resolution of the legal conflicts of a constitutional nature. Introduced on the occasion of the revision of the Constitution in 2003, this power is regulated by the Article 146 of the Constitution. The Constitutional Court shall solve legal disputes of a constitutional nature between public authorities upon the request of the President of Romania, one of the Presidents of the two chambers, the Prime Minister, or of the President of the Superior Council of Magistracy. According to the data on the website of the Constitutional Court, so far the Court has settled a number of 55 cases having subject matter legal conflicts of the constitutional nature. The Court's pronounced solution for ascertaining the legal conflicts of constitutional nature in a number of 25 cases, establishing the conduct to be followed by the parties in the conflict. Thus, the Court intervened as a mediator in a crucial moment. such the confer by the judiciary certain law-making prerogatives or by the legislative authority of certain prerogatives in justice, those related to the representation of the country before the European Union. At times of blockages of the relationships between the legislative authority and the executive authority regarding the appointment of the government or of some minister, etc. The role of the court as a peacemaker is all the more important in times when the society goes through crisis of any kind, as it was the sanitary one caused by the pandemic. As we have all noticed, the fight against the pandemic has led many countries to resort to emergency powers, which meant, inter alia, increased powers for the executive authority. However, this increased power should not destroy the balance of powers, which is the essence of the rule of law, and of course not violate the fundamental rights and freedoms. According to its role during the pandemic, the Constitutional Court adjudicates mostly at the request of the advocate of the people through the mechanism of the exceptions of unconstitutionality on the limits of the power of each public authority involved in establishing the mechanism of the state of emergency. As concerned the legal conflicts of constitutional nature, the Constitutional Court pronounced 2 decisions ascertaining legal conflicts of constitutional nature. We consider the first of them especially relevant as it refers to a conflict that involved equally the President, the Parliament, and the government. The conflict appeared at the very beginning of the COVID pandemic, and the Constitutional Court decision, which resumed the authorities in the limits of loyal constitutional behavior, is very significant for the role of the court as a peacemaker in a difficult context. By detailing a little bit this case, we point out that the onset of the pandemic occurred in Romania in a kind of complicated political context, immediately after the 2019 presidential elections and before the 2020 parliamentary elections, when political decision makers seems rather focused on the political struggle, which culminated in a legal dispute between the President of Romania and the Parliament. Thus, after the dismissal of the government by motion of censure, the President appointed as a candidate for Prime Minister the same person who held the position of Prime Minister for the government and whom Parliament had withdrawn his trust only the day before. This approach was accompanied by public statements by the President and candidate for the office of Prime Minister on the need for early elections, which means to dissolve the Parliament. In relation to these acts and statements, the President of the Chamber of Deputies and the President of the Senate notified the Constitutional Court with a settlement of a legal dispute of constitutional nature between the President and the Parliament, arguing in essence that the President exercised discretionary powers by appointing the candidate for the Prime Minister in order to cause the dissolution of the Parliament and determine early elections. The Constitutional Court found a legal dispute of constitutional nature between the President and the Parliament. The Court ordered to proceed with the new appointment of the candidate for the office of Prime Minister in compliance with the constitutional provisions, namely, in essence, in order to form a new government and not to dissolve the Parliament. Following this decision, the President appointed the same person of candidate for the office of Prime Minister, but in the same time, this idea of dissolving Parliament at early elections was abandoned. The appointed candidate had fulfilled his constitutional obligation, the Parliament has granted its confidence to the new government, and the President appointed him. In March 2020, 2 days after the appointment of the government, the President established a state of emergency by decree. In this light, it was rightly noticed in the literature that although essentially a health crisis in Romania, the COVID pandemic has triggered the institution of emergency measures that helped conceal an ongoing political and constitutional crisis. In this light, I think the role of the Constitutional Court was an essential one, is to place the public authorities involved in the procedure for the appointment of the government within the limits of the Constitution, to establish the peace in the sense of preventing the deepening of the political and social crisis. This decision is particularly relevant to the topic analyzed from the perspective of the reasoning of the court concerning constitutional loyalty, which is, in essence, represents the expression of peace in the sense of conflict preventions. On that occasion, the court held that the relationship between the authorities must operate within the constitutional framework of loyalty and cooperation. The cooperation between the authorities is a necessary and essential requirement for the proper functioning of the public authorities in the state. This is because the observance of the rule of law implies, as for the public authorities, constitutional conducts and practices which have their origin in the constitutional normative order, seen as a set of principles that substantiate the social, political, and legal relationship of a society. The second legal conflict of a constitutional nature that marked the period of pandemic concerned the procedure of the motion of censure. Therefore, a moment of sharpening of the political and implicitly social tensions, while the dismissal of the government was under discussion. The court upheld the request made by the Prime Minister of the government and found that there was a legal conflict of constitutional nature between Parliament and government, arising from Parliament's conduct with regard to the parliamentary scrutiny procedure initiated by motion of censure of 3 September 2022. Furthermore, the court ruled that Parliament is expected to debate the motion of censure tabled and to vote it in accordance with constitutional and regulatory requirements and applying the principle of constitutional loyalty. In this context, and very relevant in the light of our topic, the court held that a Parliament must take into account the nature of the motion of censure, which requires a certain speed in the procedure for debating it. Thus, it is expected to debate it within an appropriate period of time to avoid legal uncertainty by reference to its purpose. Once again, is revealed the dimension of the role of the Constitutional Court emphasized above in interpreting the Constitution in such a way to ensure stability and peace at the social level. In itself, the prolongation of the situation of uncertainty regarding the appointment of the government takes damaging effects in the social and economic terms and affect the democratic core, the values of the rule of law. As for the second point, restriction on the exercise of the fundamental rights in the context of the pandemic. We have discussed the issue in detail on other occasions, and also the advocate of the people pointed out some relevant decisions and moments on this topic. So I will resume some of the ideas as they are essential in the light of our discussions. It is about the decision that the Constitutional Court has issued regarding the measures adopted in the context of the COVID pandemic. For example, at the beginning of this period, the sanctions provided in Romania for violating the imposed measures were particularly drastic, and the control exercised by the public authorities was very strict. The public reaction to these measures was also reflected in the action of the authorities, in this case the advocate of the people, who challenged the Governance Act that included those measures. We consider that this context and these referrals brought before the Constitutional Court, as well as the decisions issued by the court, have determined that at this moment in Romania, citizens, regardless of their legal training, know better than ever under what conditions the exercise of fundamental rights and freedoms can be restricted. I remember that also Mrs. Weber, in the first panel, mentioned that the people started to challenge more the administrative decisions of the authorities. So it was a moment of awareness of their rights, but also of their constitutional limits, which we consider vital for the awareness in itself of what the rule of law means. Basically, the Constitutional Court was called to decide on the interpretation and enforcement of Article 53 of the Constitution, according to which the exercise of certain rights and freedoms may only be restricted by law, and only if necessary, as the case may be, in some specific cases, such restrictions shall only be ordered if necessary in a democratic society. The measures shall be proportional to the situation having caused it, applied without discrimination and without infringing on the existence of such rights and freedoms. The referrals brought before the court and the related debates focused in particular on the concept of law contained in the cited article, as well as on the conditions of proportionality which it enshrines. The court decided that the concept of law contained in the Article 53 of the Constitution must be approached in the narrow sense as an act of the Parliament. As a result, the court has sanctioned the restriction on the exercise of fundamental rights and freedom by the government emergency ordinance. The court stated by the same decision on the proportionality requirements that must be observed regarding the restriction on the exercise of rights and freedoms correlated with the requirement of clarity of the regulation. I also remember that the advocate of the people underlined this condition of proportionality as essential conditions for the restriction of the exercise of human rights and freedoms. This first decision in this matter has a significant impact on both the citizens and public authorities. Moreover, the decision of the court determined the adoption of a law on some measures to prevent and combat the effects of the pandemic, which was actually the frame for the restrictive measures adopted after this moment. Furthermore, the court has also issued several impactful decisions, both regarding the activity of the authorities and the fundamental rights. I think out of which a significant resonance was the one regarding the mandatory hospitalization, but also it was mentioned by Mrs. Renate Weber, the advocate of the people. I would like just to underline a little bit that, in essence, the Constitutional Court decision pronounced on mandatory hospitalization concerned the lack of a normative framework that would ensure the necessary guarantees so that mandatory hospitalization does not constitute an abusive measures. Even if it was criticized by the authorities, especially by the government, the decision still remains a notable one in terms of ensuring balance and preserving fundamental values, such as individual freedom in a context where the line that separates the use of authority from abuse is a very fragile one. So, passing to conclusions, and returning to the key value that was the center of our approach, namely the rule of law, we consider that it should be emphasized as a matter of principle that the courts are the natural protectors and promoters of the rule of law. They are key safeguards for human rights. The courts are promoters of legal certainty, guardians of the legitimate expectation of the citizens, and are gradually becoming the masters, somehow, of a legal order. Exceptional periods such as pandemic, global crisis that states have gone through, such as in 2009, and unfortunately that comes as a result of the war in the neighborhood, shed even more light on this role of the courts must have in exercise with wisdom and moderation. In this regard, the binding nature of the decision of the Constitutional Court is a major achievement of modern constitutionalism, stability factor of the Constitution, of the entire legal system, and therefore of the rule of law. The courts themselves, especially in a complex system like European Union, must find a way of dialogue in order not to cause a conflict of values and endanger themselves the legal certainty and the rule of law. Generally, the constitutional courts cannot bring about social peace if they themselves are not perceived to be able to bring about social peace. This public institutional confidence is difficult to be achieved and very fragile, so that its achievement must be a continuous process assumed by the Constitutional Court. I think it's about that magical concept, trust, mentioned also in the presentation of the professor Armin von Bogdandy in the first panel. I'll conclude underlying that I liked a lot a beautiful idea and concept mentioned by the Professor Spiridon Flogaidis, the dialogue of civilization. I think we need a dialogue of the courts, of the constitutional courts, and also this kind of dialogue of civilization in order to uphold and strengthening of the rule of law at the global level. Thank you so much.
It's a very approached subject. We will quickly pass to Mr. Mario Marazziti, co-founder of the World Coalition Against the Death Penalty, Sant'Egidio Community Italian. Apart from our colleagues, from their presentation earlier, Mr. Marazziti is approaching a very challenging theme, to say so. The challenges of aging Europe, very actual also, of aging Europe and of world forced migratory movements. The floor is yours.
Thank you, Mr. Chairman and Professor Tabaras, Professor Safta. Thank you for making possible for me to be here with you. I'm an outsider. I've been a legislator. I've been working for all my lifetime with the community of Sant'Egidio, an international, global, and local, not just NGO, but peacemaking, dialogue actor that has always been the side of the more marginalized in our societies. I've been proud, I am proud to have been a co-founder of the World Coalition Against the Death Penalty, and so much has to do with rights of the people. And in 2002, and to be part of the peace negotiation that brought to an end the civil war in Mozambique 30 years ago, October, exactly now. 1 million people died in that civil war. And it is the only case of non-governmental contribution to end a real war in our times. But rule of law and new challenges. So I will focus on the problem of the elderly and at the same time of forced migration of migrants in our times. I will anticipate some of my conclusions, which demand an answer that can be given with your help. As you perfectly know, all of the European constitutions of the second half of the 19th century and the first half of the 20th century are the offspring of the great industrial revolution and the necessity to build a model of social state, whereas they refer to social and individual rights. From this perspective, the elderly truly represented a marginal issue. They were not in sight of constitutional charts, as their numbers were small and they lived at the fringes of society. They fell under the definition of person, as it is stated by Article 3 of the Italian Constitution. But apart from this, they existed merely as retired workers entitled to have a pension and social insurance. Substantially, in the near future, we will need to strengthen the rule of law and to implement the existing laws and to expand it to a large part of our fellow citizens whose rights, which are somehow still new and flaky, are constantly neglected and underprotected. The demographic winter, besides calling for urgent measures aimed at ensuring the upcoming generational transition, demands that constitutional law pays greater attention to the rights of the elderly and less autonomous people, as the COVID-19 pandemic has undoubtedly demonstrated. The right to life, health, freedom, and dignity. a constitutional value, that of dignity, whose necessarily pluralistic consistency risks to lose its purpose due to the neglect of certain political establishments. So our time needs to reformulate the legal status of the frail person, the welfare labor market, and, at least in conjunctural terms, immigration laws and integration policies fostering the availability of legal labor and its professional and social enhancement, supported by a thorough reflection on the extent to which the borders of citizenship and human rights can be moved. Likewise, concerning migrants and refugees, who by 2020 were estimated to be 281 million people in the world, as opposed to 81 million only in 1970, we must know that 93 million of them are today forced migrants, asylum seekers fleeing from war-torn countries, persecutions, discrimination, or simply because they are the new climate refugees. The climate refugee has no acceptance in international law, but they die all the same. That's the problem. The elderly now. Let's have a look at a range of statistical figures that can be helpful in order to give a more realistic frame to our considerations. COVID-19 has been an objective litmus test. As of today, in the US, for instance, 75.3% of the 1 million people who perished to the virus were elders. About 40%, 42% of all of them lived and died in nursing homes, where a minority of elderly people resides. The same can be said of the EU. 4 out of 10 deaths happened in elderly homes and nursing homes, where, in the case of Italy, only 3% of the elderly people live overall. It simply means that even in the most tragic stage of the pandemic, the first one, at least for the victims, when the capacity of the healthcare systems was overloaded by an unprecedented amount of stress, homes, without any special assistance, protected human lives 15 times more effectively, just because they were homes and not nursing homes or homes for the elderly. So this means, because there is a problem, those who take care of the elderly lack a statute protecting individual rights, including the right to protect oneself if the staff is negligent or inhumane. A comparative study carried out by the University of Tel Aviv on the mortality rate affecting 32 countries in relation to the handling of the COVID-19 outbreak highlighted how tragically disproportionate the situation can be in those countries that share even many similarities regarding lifestyle, diet, geographical position. For example, Spain and Greece, 2 Latin countries. 15 deaths per million in Greece during the first phase of the pandemic, and in Spain, 542 per million. So 35 times more. The only difference they found, the University of Tel Aviv, was that in Spain there are many nursing homes and institutions for the elderly, and practically nothing in Greece. That is the reality. In the US, for instance, Massachusetts and Pennsylvania and Connecticut, like Lombardy, that is the richest part of Italy, but where there are more nursing homes per capita, had a death toll in America close to 80%. So this shows that one of the greatest achievements of civilization, the life that we have to live more than the previous generation, risks to be a curse. And all the debate, also the legal debate about among scholars of law, I could see when in Italy we approved the so-called anticipated living wills, the biotestamento. I have noticed that all the sentences over the last 20 years were in favor of guaranteeing the dignity of dying with dignity, but in favor of death, and that the real preoccupation, they were worried to avoid an excess of a therapeutic persistence. But I have discovered that there is a massive, larger presence of therapeutic withdrawal. So not to give the same thing to different people. That's a bigger problem, but the public debate and even among sentences is on the other side. So on this point I want to conclude. The constitutions of the new generation, like the Portuguese Constitution 1976 and the Spanish Constitution 1978, contain something about the elderly. But this has not coincided with a change in many other initiatives in other European countries. At the same time, the Article 25 of the Charter of Fundamental Rights of the European Union recognizes and respects the right of the elderly to lead a life of dignity and independence and to participate in social and cultural life. So, what is needed, in my opinion, is to try to revive the essential fabric of the policies enacting the fundamental right to social inclusion and the right to life in a historical phase where practically these rights are shrinking, and many other rights are shrinking, as the rights for the refugees and for the migrants. So it is no coincidence that in Italy, the ombudsman, the guarantor of prisoners appointed by the government, has had to deal not only with prisons, but also with care facilities for the elderly. So one last, because it's late, one last thing, I will give a longer text, but it was of the right length, but now it is too late. But I want to say that I have problems, for instance, in the fact that the European Union member states are outsourcing the assistance to the refugees. So Turkey, Libya, where we know there are incredible violations of human rights, and so, well, this is a shrinking, because the problem is to prevent the moment in which they touch the European soil, because at that time it becomes more embarrassing to deny that right. Of course, there is the problem of how civil societies in Europe will resist, will cope with that when there is a preaching that depicts this as a real danger. Then I think that the prompt and incredible, amazing answer to the Ukrainian crisis and to the refugees is a lesson. It cannot be an exception. I don't know if European countries can resist having a total difference between what we do fantastic with and for the Ukrainians and what we are not have immediately stopped to do for the Afghans that were just 7 months before. That's it, or for all the others. So there is a possibility. The community of Sant'Egidio has developed a model in which involves civil societies in hosting and accompanying the integration of the migrants based on using resources, human resources, that are not inside the public model of the states. where only the state does something. And then the states are under pressure. So this model, the humanitarian corridors, has shown itself very productive and very effective for the first 7,000 individual refugees that came in a safe way through bilateral accords between the community itself, civil society, and the states. Now, there is the possibility both that the European Union uses this model to prevent conflicts inside the member states, accepting a new way to embody in its own in their own societies the newcomers and the new future citizens, and at the same time that they can implement what the European Parliament had approved, but just by a simple majority, about a real distribution, taking care of not just of the population and of the richness of each country, the wealth of each country, but also of the social system, of other problems. So I think that, and I conclude, we can work on, don't worry, thank you. We can work on adding a new juridical tool that already exists, like the sponsorship used by Canada, but introducing a community sponsorship for not just for jobs, but also to research jobs, because we need more, and this would reduce the tension inside our societies. For asylum, where it is the civil society that before they come says we are available to host, and this would reduce again some of the tensions. And then also family sponsorship, that means there already exist in Europe a lot of networks of Syrian or refugees and so on, that can be considered for refugees that have a different concept of family, where the family is very large. It is not just mother, father, and one child, and one grandfather if survives. So this is what I wanted to put on the table with you, because these people can also be a solution or part of the solution for the elderly. That's it. Thank you.
Thank you, Mr. Marazziti, for this very different, I would say, freshful approach, and this guides me to the idea that we will never stop talking and discovering the different aspects of the rule of law, because it's an ever-freshing and ever-developing reality. I will now open the floor for discussions, and I will pick myself one aspect that Elisa was referring to, a crucial aspect, in my opinion, for the rule of law, namely the appointment of high-level judges in high Supreme Courts, in Supreme Courts, and in constitutional courts. And I will give the floor to the representatives of different jurisdictions. I already noticed that Professor Flocaitis wants to say something. Maybe Dr. Margaritis wants to add something regarding the situation in Greece. We have our colleague Bas Schotel from Netherlands, so maybe we could hear what is the situation there. Professor Iris Kanar from Israel. I think it's a hot topic there too. But I can only observe from the beginning that in this aspect, despite the fact that the organization of the judiciary in Romania was monitored for so many years, we have, I would say, Elisa, sorry, but much better system than in Spain. So the government and the parliament doesn't interfere at all with the appointment of the Supreme judges. So there is a procedure where their previous decisions are analyzed, even publicly, so the civil society can send to the Superior Council of Magistracy observations regarding their previous decisions. Then there are some theoretical contests, exams, and then the final decision rests based on a public interview with the Superior Council of Magistracy, which is made by judges, elected prosecutors, and again representatives of the civil society. But you won't believe it, even in Romania there is criticism about this method of appointment, saying that the members of the Superior Council of Magistracy have too much discretion regarding the evaluation in the interview phase, which is essential and determines the result, admitted or rejected. So, Professor Fochaitis.
Right, Professor Fochaitis would like to take the floor on the issue, taking into consideration, bringing into your consideration the Greek system. Now, the Greek system, I hope, will prove to you that nothing is absolutely, no system is absolute truth, absolute value. The Greek system was introduced with a big reform. The biggest reform in my country took place in the years from 1910 to 1912. In 1910, Greece brought into power a man whom perhaps we have heard of, Eleftherios Venizelos, a politician and provincial practicing lawyer of Crete. He became the biggest political man of my country. And he created, he changed in 2 years. He took a broke country, a destroyed country, and in 2 years, he produced a country which was reformed so well and so quickly that we could get immediately after, in 1912, into the Balkanic Wars, and then into the First World War, and create the country which you know today as Greece. It's 5 times bigger than the country which Eleftherios Venizelos had taken. Now, we have 3 Supreme Courts in Greece. We have the Conseil d'État, the Court of Audit, and which is of mixed character, court and administration at the same time, and the civil and the criminal courts. Later, in 1984, we introduced also the first and second instance administrative courts. So, in the Conseil d'État, you enter as auditor, exactly the French system. Then you become maître de requête, and then you become conseiller d'État. In every step, according to this reform, you are promoted on merit. And the Council of Magistrature for the Conseil d'État and today for all the administrative justice is composed exclusively by judges in order to maintain the independence from other interference. In the Court of Audit, you have exactly the same system. You enter as auditor, but get conseiller à la cour. And again, you have you are promoted on merit, by a Council of Magistrature, which is exclusively composed of judges. In the criminal and civil law cases, you have a developed hierarchical system of courts, and you are promoted again on merit by a council of magistrature, whatever it is, right? Yes, the magistracy, which is composed exclusively by judges. Exception is made by the Constitution ever since for the vice presidents and the presidents of the Supreme Courts, them being appointed by the Council of Ministers at full discretion. Now, this has worked for 110 years. It has, I keep saying that it is about time to finish the system, because the system does not work. It helped into making an independent judiciary in those days, but now it has been distorted. Why? First of all, because the promotion on the merit never applies. The judges hate the promotion on the merit, because somebody will be promoted and somebody will not be promoted. They are strict with the ancienneté, ancienneté, how they say?
Seniority.
Seniority. By the day they came into the office. You may be crazy, you may be stupid, you may be the worst of the judges. So, no, the principle of the promotion of the merit never, but never applies, because it is hated by the judges. Second, the Council of Magistrature is, the three of them, exclusively composed by judges. I have advocated several times that the system was good for 1910. It is not good anymore, because it is dangerous. Why it is dangerous? Because it is hermetically closed and may create networks in the organization of the judges, because they are hierarchically organized. And there is no stronger myth in the Montesquieu kind of organization of powers than the independence of the judge. No, that's the truth. Another distortion, it is very crucial, and it concerns the Supreme Court for civil and criminal cases. If you are a president of a court of appeals, then you don't have to treat dossiers, cases. You only preside and you direct. But the cases are instructed by the other judges. But if you become Supreme Court judge, Then you return to your condition. As a younger judge, you treat your own cases, you have your own cases. You have to work. When you are president of the Court of Appeals, you have to influence. You have the right to influence. But if you are now the newly appointed judge, you have to work. So, first of all, they are promoted to the Supreme Court by seniority. And second, the best of them, or the most clever of them, or the less ambitious of them, are accepted to ask not to be promoted to the Supreme Court and stay where they are. So, you see that every system is or may be angelic at the beginning and then be distorted after 100 years. No one can be trustful to anything which lasts successfully, I would say, 100 years. Even the Soviet Union collapsed after 80 years. The most mighty state in the world. They could not make it anymore. They disappeared. Now, presidents and vice presidents, there is a lot of criticism because the judges would prefer the presidents and the vice presidents to be chosen among themselves. And, but the system wants them to be appointed by the Council of Ministers. There is a lot of discussions, but I am someone who trusts more politicians than judges, because politicians are elected and they give reasons to the people if asked. In my country, the democracy is not so advanced to ask the politicians why they appointed X or Y as president or as vice president. But we have the right to ask them. Now, if we gave the possibility to the judges to choose among themselves, either they would go to the seniority, they adore seniority, or what is this? Yeah, but what is it? Oh, a microphone.
Yes, it's a microphone.
Yeah. All right. Or no. Or they would or they would be tempted to do any sorts of agreements among themselves to choose their president. So this is our system. This is the criticism by others. This is my criticism. And again, every country needs reforms every 30 years. I mean, everything becomes ripe with the time and must be reviewed. Thank you.
Thank you.
Yes, I agree with you that every system has to be renewed every 30 or 40 years. In Spain case, it's completely the reverse. It's the most, I will say, professional and clever judges that stay out of the top positions because they are so politicized. And in fact, the Supreme Courts have like a double of the salary of the normal judges, and they got assistants to do for them the work. So it's like going to heaven for judge. And about the problem of the judges, choosing judges and corporativism, I think there are technical solutions for that. And we've got some technical kind of methods to avoid an excessive corporativism. And we think it's not so difficult to avoid this problem. Right now, we have completely the opposite problem. It's much politicized at the top, and the majority of the judges are staying outside the top positions because they know they have to comply with politicians and so on and so on. And it's like more professional and more neutral to stay away from this spot. But I agree with you that every system has to balance between corporativism and political or parliamentary parliament election. But I think the main point is when the European Commission and the Rule of Law report says you have to adjust, that's the idea, you have to adjust to a standard that I agree is the separation of powers and the oversight of power. And I think in each country you have to find out the solutions to reach that point. And I think it's what they are trying to, in fact, or at least in Spain, is what they are trying to recommend us to do.
Thank you.
Maybe useful for you to know that in Italy we have a mixed system. So we have 1/3 of the members chosen by the President of the Republic, and 1/3, normally the President of the Republic must be elected by a large majority, and 1/3 is elected by the Parliament in common session between the two chambers, and the majority must be of 2/3. So then it is impossible to elect somebody without a large agreement among the different components of the parliaments and even different souls in a very fragmented society. And 1/3 by the two supreme judges, magistrature, so both the ordinaria and administrative. So there are, we say, giudici togati and giudici without toga. That's it. So this is so far we have the impression that it works. And so far I would decide the same method to appoint the top management of the Italian television. That would be much more objective and much less one-sided.
Because Tudor insists, but actually I think the Dutch situation is a bit less relevant because we don't, for starters, we don't have a constitutional court. So that's one thing. And then just the other judges, well, the judges, they are actually selected by a commission that is largely composed of judges and jurists. And there's some non-jurists involved, and they propose then the candidates, which are then nominated by the king. But the king has no political responsibility, and that's actually never an issue. And so we actually do not encounter the problem of judges. So today the discussion is it's not about judges being politicized, it's about judges being too much managerialized or administrativized. These are not existing words in English, I know. And we have the problem of diversity. So are they representative? So the majority are women of judges, and they are white, and their political affiliation, so to speak, is, let's say, progressive liberals, which makes, from my personal point of view, good judges. But there's the legitimacy issue. How representative are those judges? So this is a bit.
I asked once in the oral exams, one of my students, you go to the court, how many women you see on the desk? Because all of them, today, all judges are women. Yes, including the secretaries are women. So it was, the lower instance. No, the highest.
Yeah, but that's...
This is a wrong perception that many people have about Greece. I was once in a dinner where was also the wife of the then German ambassador. And we were talking about harassment, sexual harassment, etc. And I said that in my country, if I go to the office and I see the secretary very well made up, and I do not say a few kind words to her, how beautiful she is today, she will make my life difficult the rest of the day. So she commented very negatively, said, oh, you, the Greeks, say those things about women. And I said, look, you are talking to a country where the president of the Supreme Court is a woman. The president of the Council of State is a woman. The prosecutor general, attorney general, whatever it's called, of Greece is a woman. And if you go to courts, to the Supreme Court, most of them are women. Do you have the same thing in Germany, I said? Because they don't. Thank you.
I think that time is too short. If I start to explain the problems and the selection problems of the Supreme Court judges in Israel, and I think time is too short for us, and we will not have any lunch today. So I can't do that, but so as you said, it's very controversial. There is a special committee which is mainly composed by majority of judges and lawyers and a minority of the political members of the government and the parliament. But it changed, the commission, so in a way in the past, whoever the president of the Supreme Court wanted to nominate was by consensus between the judges and the lawyers managed to nominate them, and therefore the role of the political members was almost non-existing. But with a change, which is very difficult to explain now in short, nowadays, in the recent years, the politicians are the ones who are nominating the Supreme Court judges, and therefore managed to divert the court from a center-liberal court to a more conservative court, and it happened with the same commission nomination committee. So, and how it happened, it's a long story, but it's also part of the role that judges took to themselves in the Supreme Court. Israel doesn't have a constitution, it doesn't have a constitutional court, but the Supreme Court is sitting also as a constitution, and took to itself the power to make judicial review and declare legislation void, and that attracted all of a sudden the attention of the political powers and parties to how this nomination procedure is working, and therefore to transform it from inside. So it's a complex situation in Israel. I think that gives you at least the taste of it, but going more into detail will be much more time. Thank you.
Thank you very much. I think this discussion will continue forever if we will not end it. So I think it's time to resume our panel. Thank you everyone for the contributors, the presenters, and on the auditorium. Thank you very much for a very fruitful, useful discussion.